How can you expect the court to deal with these types of assets? Well, the starting point is the court is required to consider personal belongings. They form part of the value of the person's personal assets. Now, in K versus K, which was a particularly problematic financial remedy case where the costs were quite substantial and the parties were criticised for them, Baron J gave some practical guidance as to how we should try and agree the division of personal belongings before a trial. And I think that can equally be applied to settlement discussions outside of a court arena. I'm going to run through a few key takeaways from Baron J's judgment. Agreement should always be attempted first. As practitioners, we often see, with the benefit of some informal valuation evidence, such as an estate agent's valuation or a Zoopla valuation, an agreement can be reached and the cost of expert evidence avoided. Similar action can be taken if we're looking for a handbag valuation. We can look at historic sold prices on eBay, and there are some highly specialist used designer good websites out there as well, which provide helpful valuation, historic evidence. An SJE report is always preferable if you're in proceedings and if you can't agree outside of proceedings. Crucially, and sometimes it's forgotten, that Rule 25.5, paragraph 2, says that you cannot, without permission of the court, put expert evidence in any form before the court. So getting your application in and complying with the rules and having your ducks in a row is crucial. Now, with very high value chattels, it's also worth considering whether, alongside your application for valuation evidence, you'll need to consider tax advice, as there may well be a tax liability accruing on any sale or transfer.